Be ready. Start. It has been held that if fact is especially in the knowledge of any person, then burden of proving that fact is upon him. It is impossible for the prosecution to prove certain facts, particularly within the knowledge of the accused. Section 106 is not intended to relieve the prosecution of its burden to prove the guilt of the accused beyond reasonable doubt, but the section would apply to cases where the prosecution has succeeded in proving facts from which a reasonable inference can be drawn regarding the existence of a certain other facts unless the accused by virtue of his special knowledge regarding such facts failed to offer any explanation which might drive the court to draw a different inference. Section 106 of the Evidence Act is designed to meet certain exceptional cases in which it would be impossible for the prosecution to establish certain facts which are particularly within the knowledge of the accused. A confession or an admission is evidence against the maker of it so long as its admissibility is not excluded by some provision of law. Provisions of sections 24 to 30 of the Evidence Act and of section 164 of the CRPC deal with confessions. By virtue of the provisions of section 25 of the Evidence Act, a confession made to a police officer under no circumstance is admissible in evidence against an accused. The section deals with confessions made not only when the accused was free and not in police custody, but also with the one made by such a person before any investigation had begun. The expression accused of any offense in section 25 would cover the case of an accused who has since been put on trial, whether or not at the time when he made the confessional statement he was under arrest or in custody as an accused in that case or not. Inadmissibility of a confessional statement made to a police officer under section 25 of the Evidence Act is based on the ground of public policy. Section 25 of the Evidence Act not only bars proof of admission of an offence by an accused to a police officer or made by him while in the custody of a police officer, but also the admission contained in the confessional statement of all incriminating facts relating to the commission of an offence. Section 26 of the Evidence Act deals with partial ban to the admissibility of confessions made to a person other than a police officer, but we are not concerned with it in this case. Section 27 of the Evidence Act is in the nature of a proviso or an exception which partially lifts the ban imposed by sections 25 and 26 of the Evidence Act and makes admissible so much of such information, whether it amounts to a confession or not, as relates to the fact thereby discovered when made by a person accused of an offence while in police custody. Under section 164 CRPC, a statement or confession made in the course of an investigation may be recorded by a magistrate subject to the safeguards imposed by the section itself and can be relied upon at the trial. From a careful perusal of this first information report, we find that it discloses the motive for the murder and the manner in which the appellant committed the six murders. The appellant produced the blood-stained sword with which, according to him, he committed the murders. In our opinion, the first information report, however, is not a wholly confessional statement, but only that part of it is admissible in evidence which does not amount to a confession and is not hit by provisions of Section 25 of the Evidence Act. The relationship of the appellant with the deceased, the motive for commission of the crime, and the presence of his sister-in-law PW11 do not amount to the confession of committing any crime. Those statements are non-confessional in nature and can be used against the appellant as evidence under Section 8 of the Evidence Act. The production and seizure of the sword by the appellant at the police station, which was blood stained, is also saved by the provisions of the Evidence Act. However, the statement that the sword had been used to commit the murders as well as the manner of committing the crime is clearly inadmissible in evidence. Thus, to the limited extent as we have noticed above and save to the extent only the other portion of the first information report must be excluded from evidence as the rest of the statement amounts to confession of committing the crime and is not admissible in evidence. Thank you.